Imagine checking your mailbox and realizing one missing document could freeze your family's future. Because this January 2026 shift isn't gossip, and filing, like always, may be the fastest way to get stuck. Across the country, households are discovering that sponsoring a parent, spouse, child, or even a sibling can now feel like climbing steeper stairs. Have you already filed, or are you about to? Then the next few minutes can save you months, maybe years. Welcome back to Winds of Thought, where we translate policy into clear next steps. Today we're unpacking the early 2026 direction around the I-130 family petition, what it does, what may tighten, and the exact pressure points that create delays or denials. Here's a hard question. If scrutiny increases while your case is pending, can you prove your story without contradictions? First, quick clarity. The I-130, Petition for Alien Relative, is the starting gate for most family immigration. It's how a U.S. citizen or lawful permanent resident tells USCIS this relationship exists and it qualifies. Once approved, your relative can move to the next stage, consular processing abroad, or, if eligible, adjustment of status inside the U.S. to seek a green card. Sounds straightforward, right? The catch is that straightforward only works when your evidence is clean and complete. The I-130 covers two big buckets. One is immediate relatives, spouses, unmarried kids under 21, and parents of U.S. citizens, where visa availability is generally more direct. The other bucket is the preference lines, like adult children, married children, and siblings, where yearly limits create long waits. For decades, that system has been the main bridge for legal reunification. Millions have crossed it. Now the bridge is being rebuilt while people are still walking on it. So what's the January 2026 direction? Not tiny paperwork tweaks. Think heavier screening, more proof demands, and a stronger enforcement-first mindset that can slow approvals and raise the bar, especially in family categories. Let's walk through 5 pressure points that matter most, and I'll share the practical moves you can make in each. Ready? Pressure point 1. Deeper scrutiny and thicker documentation packets. Under newer guidance, officers are leaning harder on show me evidence, even for cases that used to glide through with basic certificates. Before, a birth record, a marriage certificate, and proof of your status often covered routine filings. Now, even simple petitions can get intense review because enhanced vetting pushes officers to ask for a fuller story. What does that look like in real life? For a spouse case, you may be expected to show a shared life, not just a wedding photo. Officers can ask for a relationship timeline, communication logs, travel history, joint statements, and affidavits from people who know you. Foreign documents may need certified translations, and any missing or unclear record can become a request for more proof. Ask yourself, if an officer doubts one detail, do you have backup proof ready? Here's why this matters. More evidence means more time to gather, more money for translations or records, and often more reliance on legal help. It can also mean longer review time, because officers are spending longer per file. A case that once moved in 6 to 12 months can stretch well beyond a year, and that's only the petition stage, not the visa or green card finish line. Pressure point 2. Tougher sponsor financial expectations. Filing the I-130 is about the relationship, but the overall process also ties to your promise to support your relative so they won't rely on public benefits. That commitment usually shows up through Form I-864, the Affidavit of Support. Historically, sponsors aimed for around 125% of the federal poverty guideline, and if they fell short, a joint sponsor often helped. Now, proposals and talk point toward a higher income bar, think 150% or more, and potentially tighter rules on when joint sponsorship can be used. Assets may get inspected with more skepticism, and I own something valuable may not be enough unless you can prove it's liquid and accessible. Can you see the ripple? A family that qualifies today might not qualify under a stricter threshold tomorrow. Let's put numbers on the feeling. For a U.S. citizen sponsoring one spouse, you might have been hovering around the high 20s in annual income, depending on the year's chart. If the benchmark rises, that target could jump into the low 30s or higher. Add more relatives and the required income climbs fast. A household of 4 can push into 50,000 plus territory. Many working families don't have that cushion. And when money becomes the gate, separation can become the price. Pressure point 3, more denials, more RFEs, more tiny errors become big problems. An RFE, request for evidence, is USCIS saying, "We're not satisfied, send more." Under a stricter posture, officers may have wider discretion to question whether a marriage is bona fide, whether family ties are adequately documented, or whether your intent looks suspicious. Even small inconsistencies, different spellings, mismatched dates, forgotten addresses can trigger a pause, an RFE, or a denial. Here's the sneaky part. Many families don't lose because the relationship isn't real. They lose because the file looks messy, a missing translation, a typo that conflicts with an earlier form, or an unexplained gap can become credibility concerns. So the question is not only, are you eligible, but also, can you prove eligibility without contradictions? If you're thinking, they'll understand, remember, officers evaluate papers, not intentions. Pressure point 4, preference categories may slow even more because of priority dates and visa bulletin movement. For capped categories, your priority date, the day USCIS receives the I-130, controls your place in line. You can't proceed to the visa step or file adjustment until your date becomes current under the monthly visa bulletin. When policy leans towards slowing family migration, those dates can crawl or even move backward. That means you can win the I-130 and still face extra years before your relative can immigrate. For some sibling lines, waits already run beyond 2 decades for certain high-demand countries. If movement slows further, those waits can stretch even longer. Think about that. A teenager can start high school and finish college while a case sits in line. So if you're in a capped category, your strategy starts with one word: sooner. Pressure point 5. Stricter adjustment of status review, even for immediate relatives already in the U.S. Many couples file where the foreign spouse is in America on a tourist or student visa, or where a child's history includes status complications. Historically, immediate relatives of U.S. citizens sometimes had more flexibility depending on the facts. Under a tougher posture, officers may treat overstays, unlawful presence, and suspected fraud with sharper suspicion. That can mean longer processing, more interviews, and higher denial risk. Consider a scenario. Someone enters on a visitor visa, then marries a U.S. citizen soon after. Even if the relationship is genuine, officers can question whether the entry was misrepresented. They may dig into timelines, messages, travel plans, and prior statements to find inconsistencies. Are you ready to explain your story clearly, calmly, and consistently under pressure? Now let's bring this down to specific family categories, because different relationships face different landmines. If you're a U.S. citizen filing for a spouse, expect heavier proof demands, possible in-person interviews, and detailed questions about daily life, finances, and future plans. The goal is to test consistency. If you're filing for parents, expect enhanced document review plus a closer look at any past immigration issues. Old overstays, past denials, or prior entries can be examined more closely than before. If you're a lawful permanent resident filing for a spouse or unmarried children, you're in preference lines with longer waits, and your own status may be examined too. Are you maintaining residence properly? Have you spent long periods outside the U.S.? Those facts can matter, and if you're filing for siblings as a U.S. citizen, you're already in the slowest lane. And policy talk sometimes questions whether that lane should shrink, not because it has happened, but because the direction tells you what to plan for. So what can you do, practically, to protect your family's timeline? Step 1. File as early as you reasonably can. Your priority date is the day USCIS receives your petition, and each month you wait can stretch an already long line. If you're waiting for the perfect time, ask yourself, will the rules be friendlier later or tighter? Step 2. Build a package that reads like a story, not a pile. Organize evidence so a tired officer can understand it fast. Timeline, key documents, supporting records, and clear labels. Don't submit the bare minimum. For spouses, think joint accounts, shared bills, leases, insurance, photos over time, and communication records that show real life. For parent or child cases, ensure names, dates, and locations match across every document, including translations. What's your weak link? Identity records, finances, or relationship proof? Step 3. Consider professional help, especially if your case has complexity. Prior overstays, previous filings, name variations, or unusual timelines. An experienced immigration attorney can spot weak points before USCIS does, prepare you for interviews, and respond to RFEs with precision. But even if you file alone, use a lawyer's mindset. Assume every claim needs proof. Step 4. Get honest about finances early. Review your income with the latest guideline chart, calculate household size correctly, and plan ahead if you're near the line. If joint sponsorship is allowed in your scenario, line it up before you file, not after an RFE arrives. If you're leaning on assets instead, document liquidity, bank statements, ownership proof, valuations, and access. Would you bet your family timeline on they'll accept it? Don't. Step 5. Accuracy is non-negotiable. Under tighter review, false statements can trigger not just denial, but serious future consequences. And even innocent mistakes can cause long delays. Triple check spelling, dates, addresses, and prior immigration history. Keep copies of everything you send. Make a checklist and mark every item before you mail or upload. A clean file is a quiet file. Step 6. If you receive an RFE, treat it like an alarm bell, not an annoyance. Deadlines can be short, often 30 to 60 days. Answer every point, provide what's asked, and explain what you can't provide with alternate evidence. If you don't understand the request, get help fast, because a weak response can become a denial. Also, know your options if a denial happens. In some cases, you can appeal or request USCIS reopen the case or reconsider it. But those paths are technical and time-sensitive. Sometimes it's smarter to fix the issue and refile with a stronger packet. The best path depends on your facts, so don't guess, get guidance. Now, a warning about the rumor machine. Immigration policy moves fast, and half-true posts can wreck good cases. Verify updates through reliable sources and official releases. And if your I-130 was filed before new standards take hold, understand that your pending case may still feel the new scrutiny through an RFE or interview. Don't assume older filing means untouched. One more reality check. Family immigration isn't the only lawful route. Depending on your situation, employment options, the diversity lottery, humanitarian pathways, or other strategies might make sense. Each route has its own rules, but knowing alternatives can reduce panic and help you plan. The point isn't to abandon family petitions, it's to avoid having only one plan. Let's talk about the mistakes that have become more expensive under a stricter posture. Number 1. Rushing a weak packet because you're scared of changes. Speed without structure backfires. Number 2. Hiding old immigration violations or past denials. Those records often surface, and when they do, credibility collapses. Number 3. Failing to maintain required status while waiting when the law expects you to. Number 4. Not updating USCIS when you move, and that can lead you to miss notices, miss deadlines, and lose time. Zooming out, what we're watching is a shift away from the idea that family reunification is always the default priority. Whether you support that or oppose it, it changes how you should plan. If the direction continues, expect more barriers, more screening, and slower movement in family categories. And here's the question. Would you rather be surprised by that or ready for it? I want to be direct. These changes can make the process harder. More paperwork, more interviews, more financial hurdles. Some petitions that once got approved may now be questioned, delayed, or denied. That's a painful truth in 2026. But hear this too, many families still succeed every year. Preparation turns fear into steps. Hope is not a strategy, preparation is. If you act early, organize proof like a story, and get professional help when you need it, you can still reunite lawfully. It may take more time and more effort, but it remains possible. And if you're watching this because you're worried, take a breath. Learning before you file is a powerful advantage. Before you go, here's your simple action plan for tonight. Make a document folder, list every name variation, collect identity records, and start a relationship timeline. Then run your finances and see where you stand. If anything feels unclear, book a consult and ask targeted questions. The earlier you build, the less you scramble later. Keep copies and timelines together in one folder. Paperwork is painful, but separation is worse. If this breakdown helped, please hit like right now and subscribe to Winds of Thought so you don't miss future updates and practical checklists. Share this with someone preparing an I-130 right now, because one missed detail can become a year of waiting. And tell me in the comments, which family category are you filing for, and what's your biggest worry? We'll keep tracking policy shifts, translating the fine print, and giving you the clearest next steps we can. Until next time, stay organized, stay honest, and keep moving forward, one document at a time.